So here you go. This is Emily C., my new bestie.
I hate the idea that someone out there hates me. I even hate thinking that Al-Qaeda hates me. I think if they got to know me, they wouldn't hate me.
This stole the show. Emily C. was phenomenal.
There's something you need to know.
What?
You're doing great.
Look at my baby. Here she is. Emily. 10 out of 10. Huge fan.
I see Emily C says 123. I trust her. She's really good.
Listen, Turtle. You gotta watch your language. I'm already live. So you need to follow the FCC guidelines.
She destroyed, left nothing in her path. It was so good.
Hello, everybody. I'm Emily C. You might know me as Colin Albert or Laura McLaughlin or Beverly Cannoni. But today I'm just me. And today I am as excited as you are. I'm reading the chat right now and seeing how excited you all are about hearing the sidebars, hearing from Corri about these sidebars. And I mean, I'm literally just as excited as you guys are. I just saw somebody said that they think that Beverly Cannoni is watching from home. Like, hi, Bev. Welcome. I'm Emily C. Big, what's the opposite of a fan? But like somebody who watches but like doesn't enjoy watching. That's how I feel about your work. And I'm glad we're getting to know you a little bit better through these sidebar transcripts. I wanted to take a second before I bring Queen Corri Hopkins on, and before she can get all like humble and make me stop, to tell you guys how amazing I think this woman is. I am so inspired by people who see a problem, realize that they have the skills and the knowledge to fix that problem, and make a big stink about it and don't stop until that problem is fixed. And that is Corri Hopkins. She got obsessed with the Karen Read trial, just like all of us. And she expected, because she understands like how this system works, that at the end of the trial, the documents that were supposed to be public would be public, because like, why wouldn't the system operate the way that it's supposed to? And when it didn't, she took action and she filed FOIA requests, because that's what you do in this system. And she got ignored half the time. And she said, oh, well, you can't ignore me. And she filed lawsuits. And then we're finally, all of us are reaping the benefits of her being stubborn and smart and not giving up until what is meant to be public is public. And she doesn't have like a dog in this fight. She doesn't live in Massachusetts. She doesn't know any of the people involved in this. She is doing this because it's the right thing to do. And those are my favorite kind of people. So please join me in welcoming Corri Hopkins. Welcome.
Hi. You know, if I knew you were going to do that in advance, I would take issue with it.
That's why I didn't tell you. And that's why I kept you backstage. But really, it is so cool to see, like, especially in this environment where it's kind of like we all feel a little bit like helpless and a little bit like we see this problem and we see like we hear that quote a lot, like sunlight is the best disinfectant. And I feel like we almost hear it so much that it loses its meaning. But really what you're doing is bringing sunlight to a system that would continue a downward spiral if it had the opportunity to. Like the people in power that benefit from us not knowing the truth or us not seeing everything the way that we're supposed to be able to, have no incentive to stop without people like you making public what they're doing. And that is these sidebar transcripts.
Well, the legislature in Massachusetts, I don't know what it's called. The legislature in North Carolina, it's the General Assembly. So say the legislature in Massachusetts,
Sure.
they said that the public records law is intended to be the sunlight, the disinfectant. Information is the bread and butter of democracy. These are quotes from the SJC. The government in Massachusetts has said we want public records law to be very user-friendly, which it is, so that there will be sunlight, and so people should use it as such.
Like, it started to feel like that was true in all cases except for this trial. Like, it almost felt like if we requested documents for anything else, that we would just get them the way that we were supposed to, like, no problem. I want to try that and see, test out my hypothesis. But then it felt like you would say, like, hey, can I get this with docket number blah, 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 care and retrial? And they were like, ooh, I don't know if we're allowed to do that.
Yep, that sounds about right.
Can you tell us before we get started how you felt the day that the sidebar transcripts finally showed up in your inbox?
Yesterday, I was very excited. I was glad that there's a court order in place that said that the DA's office had to provide these, at least the first batch of sidebar transcripts by yesterday. So I was glad that they did. I don't know. We don't have a schedule set for the next, tranche of transcripts, but the standard is a reasonable time, which is often the standard in the law, and you can fight about it or not. So hopefully things will proceed at a reasonable pace, kind of like this set of transcripts did.
Something else, like even in your answer about that I noticed with you going through this process is you were relentless in your like pursuit of this, but also very respectful of like the people that you were communicating with, even people that were frustrating you. You were very like, well, this is law, and like, just so you know, like I'm citing blah 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 CSW, like if the whole thing. And I feel like you became a thorn in their side that they were also like kind of impressed by, like that they were kind of like, oh shoot, like she actually knows what she's talking about.
I can't speak to that necessarily what the DA's office is thinking at any point in time, but obviously I, communicate with opposing counsel for a living. So I'm kind of used to when I want to, I'm using my words in a professional manner because I think that's the fastest way to get what you want. And in this case, in all of the lawsuits related to under the public records law, the law is so straightforward that I wasn't like making a creative legal argument here. It is black and white in all of the cases that I filed. So it was kind of easy to be on the moral high road because I was also on the legal high road.
You're like, well, this is literally what you're supposed to do. So can you just do it already and like save us all the trouble?
Yeah. And largely they did. After I filed the lawsuits, they pretty much, the DA's office fought back a little bit, but largely they were, conceded the state of the law and were like, yeah, you're right. Okay, fine. We'll do it.
But even the fact that it took to getting to a loss, like escalated it to the like maximum without, I guess they could have gone one more step and had you like come here, which I was halfway hoping for, you guys, selfishly. But like, yeah, yes, they did comply, but you took it to the furthest that it didn't need to get that far, right?
It shouldn't have had to get that far, but I'd seen a lot of the dockets for these state agencies, and I saw that in a lot of cases with some of them, folks file a lawsuit and 5 minutes later, they've got the documents that they wanted, which seems sort of like a I dare you to sue approach. So obviously I'm game for that dare, so.
You're like, dare me. Before we get started, for anybody that is like unfamiliar with the idea of like these sidebar transcripts, why was that something that you were so like passionate about getting to the public?
Well, I think for anyone who watched the trial, we know that the attorneys could not make objections in open court. They had to go to sidebar if they needed to discuss anything. So a significant chunk of the case is litigated at sidebar. A lot of evidentiary decisions that we wonder, why did it unfold the way it did? A lot of that is at sidebar, much more so than the average case. So we knew the sidebars were going to be important. And my friend Nikki Conway encouraged me very much to work on the sidebar. She had been working on trying to get them for a long time. And I was like, ugh, that's never going to work, never going to work. But she was just kept pushing and asking me about it. And I really sat down and looked at what she was showing me. And I was like, oh my God, she's right. This is black and white. This is easy. This should be a layup. So that I figured, a nice 3 lawsuits pending would be a good number, and just to go for it, because there's so much material here. It's crazy.
Yeah. Okay. So before we get started, you guys, so we're going to take you through some of these documents. Before we do that, I wanted to poll the chat. I've never done a poll before, so we'll see how this goes. But I wanted to ask you guys how you want us to do this. So the 2 options are going to be either I'll display the text on the screen, or Corri and I will read it, and you don't need to follow along with anything. I am curious about this because I feel like sometimes when the text is on the screen, then there's like spoilers, but also it's like kind of nice to be able to follow along. So how should we do this? Why can't I start poll? Oh man, hold on. I thought I did this right. Corri, while I figure this out, tell everybody something.
I'm working on my outfit, Alan Jackson tie mode. Hopefully I don't choke. Trying to tie live. It's coming together okay. Oh, okay. Yeah, I can't do anything fancy. No double Windsor situation. But it's tough to be AJ. There's a lot going on. I don't have like pocket squares, but I got cash money.
Yes.
And then let's see.
And can you tell everyone where we're starting today? What transcripts we're going to be doing?
Oh yeah, I thought we would start with the Colin Albert transcript, because that one is there are lengthy sidebars, quite a few of them, and it's pretty much sticks to the court, Lally, and Alan Jackson, at least for that day. It's entertaining. And then if we, have time or whatever, maybe we can try some new ones. I haven't read them all by any means. I've just sort of flipped through them quickly.
Okay. It seems like display the text on the screen is the runaway favorite. So that's what we'll do. 63%. You guys are great. Yes. Wait, I'm obsessed with you. Every single thing about you. Okay, so Corri, tell me where we should start.
So are you putting them on the screen?
Yeah.
Okay.
The people have spoken.
Okay, so if you pull up the number 19 transcript, volume 19, if you will.
Yes. Also, I'm going to write them down as we go so that I can put it, so that I can write it. Wait, how come the one that you sent me, trial 1 OCR?
That's the one that has like the searchable ones. Do you have the other one
still?
But that,
yeah.
I could send that to you.
No, I have the other one.
Okay. Yeah,
Okay.
they there's 20 volumes, but in the first half of the transcripts, about half, the ones with redactions are not searchable, just because of the way I assume they flattened the PDF when they finished it after they're doing the redactions. So I had to convert some of them into OCR searchable, format, whatever.
You're amazing. Like, you guys, not only is she getting these documents, then she's also having to like do work to make them easier for us. Okay, volume 19. What?
Yeah.
Where are we
I
starting?
just did like Control F for sidebars, but
Mhm.
I wrote down the sidebars if that's more helpful. Page 21 is the first one.
I'm right on page 21. Here we go, guys. And that is Carter knocking on the door. Yay. Wait, while I'm finding this. So when my dog knocks on the door, he like scratches the door, and Carter learned that we'll open the door for Teddy when he scratches. So now he'll knock and then scratch. Because
really
we wouldn't
cute.
open if he was knocking, but we would open for Teddy. Okay.
That's hilarious, actually. Very smart of him.
I know. The first time he like really did trick me, I opened the door and I was like, oh my gosh, I was expecting a dog. Share screen. Add to stage. Here we go.
I mean, going through these is like so wild. It like, obviously I wish we could have heard this during trial when we were really in the zone, but it kind of brings you right back to where we were because it's so every cliche that we sort of got used to, Lally's sort of droning on sentences and everything is all over these sidebars.
It like is almost validating, like, oh, okay, even Bev was like a little bit annoyed by Lally droning on. And yeah. Whereupon there was a sidebar conference as follows. Okay.
All right, should I start as Jackson?
Yes. Wait, I need to put my Bev on.
Can you do the court and Lally? Is that too much?
Yeah.
Okay.
No, of course not.
I know. You transition between characters like no one I know, so you got it.
You'll know because I'll have my cigarette.
God, that's such an incredible detail. Okay, Jackson. This photograph establishes, okay, so sorry, to reframe, we're doing Colin Albert and Jackson is trying to get in. I believe these are the wedding pictures from Courtney Proctor's wedding in which Michael Proctor and Colin Albert were in the wedding party. I think that's the picture that they're talking about here. Okay.
Yes, and Colin Albert was the ring bearer, but they don't really know each other very well at all. They actually needed to introduce themselves when Proctor went to interview Julie and Chris Albert. He said, after formal introductions.
So ridiculous.
Mm-hmm.
Okay. Your Honor, this photograph establishes a close familial relationship between the Albert family, specifically this witness, and the Proctor family.
Okay, he testified to that just now.
I know he did, and I want photographic evidence of it as well. The jurors are entitled to see it. I'm about to ask him a series of questions about being in the wedding, being part of the wedding party. The fact that that's him, the fact that that is Michael Proctor.
Okay, so Michael Proctor, because this is DD for identification, is what looks to be a young man on the left-hand side, far left of the photo. And Colin Albert, this witness, appears to be the child standing next to the bride. How many years ago was this?
I want to say it was 2011, either 12 or 13. 12, I think.
Okay. What is the Commonwealth's position on this? The Commonwealth objects as it is irrelevant and the time period is far too removed to have any relevancy whatsoever. Furthermore, any relationship between this witness and Julie Proctor, again, goes to bias. Goes to what? It could be improper impeachment or bias questioning for the trooper. But again, impeachment bears to the witness on the stand pursuant to the case law. This witness is not an investigator. His bias has absolutely no relevancy whatsoever. There is no bias just because he knows a trooper.
I couldn't disagree in stronger terms. It is both of their biases, and the fact that the photograph was taken several years ago establishes a long-standing familial relationship between this witness and the investigator, who ultimately was the person in charge of and did, in fact, conduct the investigation. It is the level of comfort that they had with each other. The bias of Trooper Proctor showed the lack of investigation on Trooper Proctor's part of this particular witness. He's obviously a seminal witness. The prosecution called him to the stand. We didn't call him to the stand. The jurors are entitled to realize the depth and nature of the familial relationship, and I think the photograph speaks for itself.
So the photographs are cumulative.
I'm sorry, the photographs are
Cumulative. I mean, he said not that close with the family, but close. And then he said more close when I was younger. So I understand you want this in. You need to establish a little bit more of why. I'm not letting it in now. I'm not inclined to let it in. Let's see if you can develop it a little bit more, which doesn't mean that you can describe the picture intentionally.
Okay, you're saying it's cumulative. If I can't use the photo and I can't describe the photo, how am I supposed to establish to the witness's satisfaction or the court's satisfaction that the witness has a deep familial relationship in the photo if I can't even describe it?
You can talk about it without. You're a skilled trial lawyer. You know how to get this in.
I know.
So I'll give it back to you and we'll see where you go with it. It's not coming in right now.
May I give it back to the witness so I can ask him about it?
Sure. And scene.
And scene. Oh, I like that. Yes, let's do that for everyone.
Yes.
And you know she rolled her eyes into the back of her head when she said sure.
Also, when she said, you're a skilled trial lawyer, like it's the funniest way, like it's a compliment, but she's not meaning it as a compliment.
It is,
Like,
it
she's
is
like,
yeah, very condescending.
yeah, you're a skilled trial lawyer.
The next
Okay.
one's on page 27.
Page 27.
So it's funny because the length between these sidebars is pretty short. I don't remember. I just watched the Colin Albert earlier today. I listened to it on the trial channel, so you don't really get because it's so smooth, I can hardly even tell when the sidebars happen. But these are 1 minute or less between these sidebars. This was a rough day.
Good day for us.
Great day for us. Okay, maybe not a great day for justice. All right, Jackson. I don't understand how this is cumulative or not relevant. They are literally standing in the same wedding party. And when I ask if that is a wedding party, counsel's objecting and it's getting sustained. What more can I ask about the foundation of this photograph?
So I don't see why you need the photograph of a wedding that's 10 years ago.
Because I'm choosing what evidence I want to present to a jury to establish bias. It's one thing for them to hear about it. It's another for them to see it. A picture is worth 1,000 words. This is basic hornbook trial lawyering.
Okay, I disagree with you on that. Tell me your specific reason.
My specific reason is because that man on the left interviewed that young man, now a grown man, on the right.
And you just got through that. You just got that through the witness.
I realize that. But the visual of having them in the same wedding party at the same time is powerful information that the jurors can weigh and balance in determining to assign credibility, not only to this witness as to his description about the relationship with the Proctors, but ultimately with Michael Proctor and his relationship with the Alberts.
What do you say, Commonwealth? Your Honor, the fact that he is in this wedding party as someone 12 years ago when he's a child again, the relationship of a family does not equate to a relationship to an individual. So the fact that he's in a wedding party as a ring bearer and the brother of the bride is also in the same wedding party 12 years ago has absolutely no relevance whatsoever to 10 years later. Any interaction they may or may not have had. And as far as the investigation is concerned, again, this is a trooper who, yes, he's involved in the investigation, but is it in evidence that he interviewed this witness?
Yes, he was asked by Mr. Lally yesterday.
Fine. And you told me that you were going to go through the ease with which he feels with the investigator, and then the investigator not going further. You didn't do any of that just now.
It's coming. I was going to publish.
It might help you get the photograph in.
Okay.
Scene.
Okay,
I feel like they are confused about how often like family weddings happen. Like they keep being like 12 years ago. It's like, yeah, but like Courtney only got married once. So like maybe if she had like gotten divorced and gotten remarried, then they would have had a more recent picture from her new wedding.
Great point. Okay, the next one's on page 38. At the bottom.
Whereupon there was a sidebar conference as follows. So, Mr. Jackson, are you telling me now, after this line of questioning, that this photo that I view as cumulative is essential to the bias of this witness because this witness is your third-party culprit or a third-party culprit witness of yours? Is that why you intend to introduce this exhibit?
No, I don't believe that we are forced at this point to put him in a category of third-party culprit. Evidence is still coming in from the Commonwealth. The evidence is still being explored by the defense. This photograph is specifically to establish the bias and lack of investigation or lack of proper investigation by an investigator. This is evidence that the investigator never should have been interviewing this witness in the first place. It should have lasted far longer than 10 minutes. They should have done their due diligence. They did nothing. They never looked at the phones. They never looked at the text messages. They never looked at the phone. They never saw an extraction. This was a 10-minute conversation with someone a year and a half after the fact that they left alone for pretty much a year and a half, notwithstanding the fact that he was at the house for the interview at or around the time that John O'Keefe was injured. And the court seems to have an issue with establishing basic bias, and that's part of our defense. This entire investigation has been crippled by bias, personal relationships, favoritism, etc. This is absolutely some of the best evidence we have of that. It's not cumulative of anything. We haven't put photographs in. It's not like this is the 10th photograph, one, and it's certainly not more prejudicial than probative. It's highly probative to the relationship and the interpersonal relationships that these witnesses have with this, especially this witness has with the Proctor family.
What is the Commonwealth's position? The Commonwealth's position is the same. It's not evidence of that. And as far as it bears on the investigation, that does not bear on this witness. He doesn't control what questions are asked or what things are asked of him. Furthermore, as far as anything to do with third-party culprit, there's no evidence of third-party culprit because there is no evidence of a third-party culprit specifically as it relates to this witness or numerous witnesses who have already come and testified before this jury that he wasn't even there at the same time as Mr. O'Keefe was. All right, so I asked you that, Mr. Jackson, because I think that might be a bias to let it in. But on that basis, it is strictly cumulative and it's not coming in. Is there anything else you want to say?
If we develop a third-party culprit defense to our satisfaction, ultimately that we are comfortable with, and ultimately that the court is comfortable with, I think that should come in for that purpose. However, irrespective,
you can renew it.
I appreciate that. I appreciate the court leaving the door open, but I believe strongly that this goes to a Bowdoin defense as well, which is what we are really exploring at this point. It's a lack of investigative interest in this witness. Why? Because he's a kid that he's known his whole life. I mean,
I get that. You got all that into evidence, which is why I contend your own photograph is cumulative. But I will leave it open if you tie it in otherwise. And just so you know, it's DD, okay?
Thank you.
And scene. There is something very satisfying about Jackson's speech at the beginning of that one. Like he said all the things I like hoped that he would say.
He throws in like rhetorical devices in his, on the spot spiels, the way people like think about them for weeks on end when they're like writing a play or something like that. They just spill out of him the various rhetorical devices. The next one's page 56. He's just phenomenal at it, which I'm sure enraged. Well, I won't speculate, but I can't imagine anyone else who was opposite him was thrilled about it.
Page 56. Whereupon photograph was entered and marked FF for, no, that's not that. Whereupon there was a sidebar conference as follows. So tell me what you're planning on doing, Mr. Jackson. Start with FF.
FF is just an enlargement of EE, which is that single photo.
Okay, so EE, just for the record, appears to be 6 thumbnails with an additional 6 partials.
Yesterday, Mr. Lally opened the door to this line of inquiry, presenting a photograph in February that he claims was in February of this particular witness.
Yes, I was just trying to go back and find the date. What was the photo that's in evidence? Like February 11th or something?
Yannetti. That's what the testimony was. Jackson, which we dispute. But given the fact that he opened the door, he specifically asked the witness questions about his face, his hands, his extremities, etc., implying that this witness, as having been in a fight. He wasn't in a fight. He's got no injury suggestive of fight, etc. This or that particular photo is manipulable. That photo was taken by a family member. It was on their phones. It was on their own data.
So I just have to ask, though, because I missed it, where is there evidence that it was manipulated?
I think the fact that it's manipulable is the evidence that needs to be weighed and balanced. I don't have to prove that it was manipulated, but I
can say that there is no evidence of that. But go ahead, I'll hear this.
So what I can prove is that on February 26th, that photo was not manipulable because it doesn't belong to any of the parties. This was taken at an event logo. It is taken by an event staff member. So they had no access to dates, times, metadata, changing anything, etc. It shows very clearly that this witness appeared significantly injured, white knuckles, indicating a fight, indicating some level of violence, indicating a physical altercation, etc.
What do you say, Mr. Lally? Your Honor, I don't know that there is any evidence that this comes from a source or that it's not able to be manipulated. I also know, I don't know what that is on the EE that's on the side there, as far as whatever labeling is on there is complete and utter hearsay. I don't know what any relevancy any of the other photos have, but as it pertains to this event, it is irrelevant. There is no evidence that the first photograph is manipulated. There is no evidence that the first photograph wasn't taken on February 11th. And if it was, then there is absolutely no relevancy to this.
Just as an aside, I have no idea what Lally said during that entire soliloquy. I have no idea what was accomplished except that he doesn't want Mr. Jackson to get his way.
I think that he was trying to say that the logo from like Johnny, wherever, Fenway Johnny's, he was like, I don't know what that thing is on the side. Like, it's the logo from Fenway Johnny's.
But he's never going to say anything that directly. So
yeah.
10 minutes later. Okay. Mr. Lally did not have to put that evidence in. He chose to open the door to this. He's put the relevance of this right before the court. He doesn't get to have his cake and eat it too, saying there's no injuries and knowing full well that we have a photo that shows significant injuries.
Side note, I feel like Lally's sitting there with a piece of cake, like, oh, wait. All right, you're telling me it's February 26th. And just so it's clear, EE is something from Facebook, from someone named Caitlin who posted it. That's not a Caitlin in this case, correct?
No.
And it's a bunch of young adults posing and partying. What I'll let you do, because it appears that the injuries to Mr. Albert's knuckles on his right hand in FF are not recent, I will let you put it in Colin Albert 34 means he posted this himself.
I'm assuming he did.
Okay, so the Colin Albert 34 will come off because you don't know. You can show him. I'm not letting EE in.
I would say I'll redact everything on EE. He has already established, I don't need EE. He just established that he was there on the 26th. That's all I need.
Right, so you can show him this and you can put this. I realize it's post February 11th. Miss McDermott, could I have that photograph? What exhibit number is the photo? I think it's either 83 or 84. 83 or 84? It's in the book. Miss McLaughlin's going to get it. Okay. Do you know if you can see his right hand in that? I think it's hanging down by his side and you can see it.
Oh, I think my thing skipped. But
Jackson just says it's around the neck. It's the one where he's like posing with his arm around whoever that was. Right. You can still see it, yes. But there was a separate one where he doesn't have his arm around somebody, and I think that's the right hand. Is that the right hand? I believe it is, yes. Your Honor, for the record, also with those exhibits, as the court had requested, we redacted the dates off those. Yes. Oh, thank you. Also, showing right knuckles in 82. In 83, you can see his right hand. Okay. I'm going to give you that. It's giving you quite a bit of leeway, Mr. Jackson. So that has to be redacted if you intend to show it. So these have exhibit numbers on them. These are trial exhibits. We need these.
I'll just ask my IT person to just show this portion without the...
Yes. I don't think you can separate that.
No, that's impossible.
The Johnnies, all right? I'll give you EE in case you need it because he doesn't remember.
Understood. Thank you.
You need to physically put it in evidence first. And scene. Oh my
I didn't know
God.
that they had such a robust discussion about the knuckles with Bev. Page 69 is the next one.
I feel like everything that that Bev is fighting against is just proof that it was important. Like, I think there were some people in the trial, like, that were like, oh, Jackson's kind of droning on about this picture. Like, we don't know if that could have happened on January 29th or if it was like happened later. And it's like, well, the fact that Bev is fighting this so hard tells me that she thought it was important. Whereupon there was a sidebar conference as follows. Wait, let me write this down. All right. So this is one of the videos that people were kind enough to send me. Okay, wait. So this is some of you guys, two of you guys probably in the chat had videos of Colin Albert fighting. Okay. So this is one of the videos that people were kind enough to send me. There are two drunken videos with this kid. Is that right? That you sent me?
I don't know if they're drunken or not, but 2 videos of the kid.
Okay.
One is just to define them. Just to define them. One of them is the Advantage Boys. I'll F you up. And the other one is KO bang bang. 2 separate videos.
Okay. Neither one of them depicts fighting, right?
They both threaten fighting significantly.
What do you say, Mr. Lally? There are videos of a high school kid talking about a hockey team. There's no evidence that any fight ever occurred between himself and this group. There's no evidence that was ever actually followed up on. So it doesn't go to bias. It doesn't go to impeachment. It goes strictly to character, which is subject to the motion in limine, which the court allowed as far as reference to any of these witnesses. So I don't see any relevance whatsoever to, it has nothing to do with John O'Keefe. It has nothing to do with anybody that has anything to do with this case. Online social media fodder is what it is.
That's not online social media fodder when he's threatening to, quote, beat your ass, pardon my French, to F you up. I'm gonna F you up. I'm gonna beat your ass. KO means knockout. Bang, bang. These are not innocent musings of a child. These are a grown young man making violent threats towards other individuals, and he testified, I've never been in a fight in my life. The Commonwealth is doing their absolute best to sanitize this person's reputation. It is wrong. It is a fraud on the jury.
I disagree with all of that, but
the court disagrees that the Commonwealth is trying to sanitize this young man as an Eddie Haskell who has never been in a fight.
Hold on. And committing a fraud upon this jury?
No, I'm not saying that.
You just did say that.
He did just say it.
You did just say that.
I'm not saying that he's committing the fraud. I'm saying the witness is committing the fraud on the jury. It's not a true and accurate representation of his.
So explain to me. We are going to need to play the video and have voir dire.
I'm happy to.
All right. I thought it was two different videos.
They are.
Which one are you trying? Which one are you planning to try and introduce?
I was going to do Advantage Boys first, and then Bang Bang second.
I don't remember. I watched these whenever you gave them to me. I just remember two drunken videos.
It's been a while. They're probably 10 seconds each. They're not long. Maybe one is 15 seconds.
So what I'd like to do, we will let the jury out. I'd like to see the videos again on the screen as the jury would see them.
Sure.
And then I'll hear we'll see them. We'll have a voir dire of this witness. Then I'll hear your arguments. Then I'm going to go watch them again in my lobby. That's how I'd like to do it.
Yes, Your Honor.
So it will be a long break for the jurors, and you all will get a very short break afterwards, okay?
Understood.
Whereupon the Sidebah concluded scene.
I'm fascinated that she wanted to watch this so many times or cared that much, but whatever.
I feel like maybe she wanted to make some phone calls while she was watching it. Like, hey, Michael Morrissey, I'm trying to not let this in. Jackson made all the points that I'm supposed to let it in. What else can I do?
He doesn't know the answer to an evidentiary question. Okay, there's a very short one where she lets in the video, but it is like literally one line. So the next one after that is 102. I didn't realize Colin Albert Day was so spicy in Sidebar land.
I remember him just like sitting there, like twiddling his thumbs while they were up in Sidebar. Like he was like, doo-doo, like, oh, where am I? What am I doing here?
I just listened to it again today and it was painful. I don't think I paid attention to it the first time around. And he's been so obviously coached to say, I don't know, to like everything that Jackson said. It's too obvious. It's like, and this is the pattern with, I think, a lot of the Commonwealth's witnesses, which is that they were coached like halfway. They were told to say, I don't know, basically all the time, but not like during certain incredibly obvious questions. There were no nuances in the coaching.
There were 3 things that he knew. So, like, in his DNA, he knew that he left 34 Fairview at 12:10. He knew for sure that he went up 3 flights of stairs when he got home. Like, that is in his DNA. He knows that for sure. And he knows that he was walking up the driveway and then he fell in the driveway. And I think I had a beverage or something in my left hand. So I caught myself with my right hand and then I fell in the driveway.
And that was
Besides that, he doesn't know anything.
anything.
Okay. Whereupon there was a sidebar conference as follows. Lally never starts. This is ballsy. I just wanted to clarify with the court based on my understanding of the question. I believe the door has been opened as far as harassment with this witness as well, and I intend to go down that road. Okay. Do you want to point to specifics? I think specifically what was asked as far as the timing, as far as you never talked about this case with family or friends for 2.5 years, and then you indicated no, just more recently. And I think in order to explain sort of why that is, it is in reference to the harassment this witness has sustained. What do you say, Mr. Jackson?
With all due respect, that is a ridiculous argument for opening the door. Mr. Lally is desperate to get anything he can in about these witnesses being harassed. I did not come anywhere close to asking those questions. Oh, especially about yesterday. My questioning was tight and thoroughly, narrowly tailored to the issues concerning this witness's credibility, and I questioned based on the door that opened of his violent tendencies. I didn't come anywhere near asking a question about whether or not he'd been harassed, whether or not he had been contacted by the police based on harassment. I asked him, have you been, I have to be able to ask. We have to be able to ask. How many times have you spoken to the police about this case, this specific case, not harassment? And that's what I asked.
What do you intend to ask? I do have in my notes at the very beginning, I wrote down that I believe the door was opened, Mr. Jackson. Frankly, I was surprised. It is in the beginning when you went through the whole litany of the preparation and just a couple of other things that I didn't get to write down. You've been thinking about this case. How long have you been thinking about this case? And he said, since people started writing about me on the internet, which was in response to the question as phrased. But tell me, what do you intend to get into, Mr. Lally? Just following up on that, Your Honor, as far as people writing about you on the internet, what was that? When was that? What did that entail? All right, I'm going to give him some headway on that. Like I said, frankly, I was surprised.
We are getting to a point, Your Honor, where we can't ask anything. We are being hamstrung because Mr. Lally has got to come up with, I'll say, what color is the sky? And he's going to say, well, he said blue. He felt blue in years past because he's been harassed. It's such a square peg in a round hole. We are getting to the point that we can't defend this case without fear that...
You just have to be careful and skilled, counsel.
Oh, I think I'm careful and I think I'm skilled. I didn't come anywhere close to opening the door, Your Honor.
Well, unfortunately, I believe you did. So I'm going to give him a little leeway on this. And scene.
Okay, the next one is...
Also, hi, Aiden. Welcome and perfect timing because there you go. that sidebar was all about you. What page are we going to next?
183.
I mean, they actually they made some headway without a sidebar.
They did somewhat. I cannot. I cannot believe. First of all, I love Jackson's analogy. We're getting to the point where I say blue. He says, "Oh, I'm blue." I mean, that is freaking hilarious. I don't know how people didn't laugh in that sidebar. And it's
Bev
true.
was like so riled up. It's like scary to be around somebody that's like that fired up.
And the question that Jackson asked was, when did you start thinking about this case? Because he trapped Colin into saying, oh, I'd never thought about this case ever. Oh, except for I actually, yes, I did meet with Mr. Lally multiple times or whatever it was. He trapped him. And so Jackson says, when did you start thinking about the case? And he said that, online harassment thing. He didn't say a date, which was the question. It should have elicited a response of a date, or I don't know, would have been more appropriate for Colin, at least.
Well, and also like the correct answer is like, I started thinking about this case like the day that it happened because this has been affecting my entire family.
It's funny that you say that because Jackson's like, really? You didn't start thinking about this case when your uncle found a dead body on his lawn?
And Colin's just like, nope.
Also,
I recently watched the motions in limine from before this first trial, and Lally and Jackson both, or I think it was Yannetti, both make arguments that they're not planning to bring in anything about the harassment. And Bev's response is, well, I still think it should be able to come in. I don't want the witnesses to feel like they can't give their testimony the way that they want to. If they want to talk about it, I want to let them. And like, ew. Okay. Whereupon there was a sidebar conference as follows. Oh, Mr. Lally's getting ballsy. He's starting again. He's starting by saying, I'm sorry. I'm sorry. This is just selfishly on my own part. I was just looking at the time and I don't know, I'm not going to finish with him. And this might be the easiest place for me to pick up tomorrow with this witness. I can keep going if the court wants.
Okay, I'll be Yannetti. I'm completely fine with that.
I was trying to figure out whether you were going to start with 7 minutes. I didn't know if we had any more. Would you have started with 7 minutes left?
No.
Okay.
Yesterday I should have come to sidebar to say we end early. It was yesterday or the day before. Anyway, no, I'm fine with that.
I don't have a problem with it. Okay. Any surprises tomorrow? I mean, evidentiary issues? I'm going to let the jury go.
That's fine.
So Lally was literally like, I'm bored. Can we go home now?
Pretty much. So I think the next one starts on this page, actually.
Okay, we're back on the record. So this is the next day.
I think that this is at she excuses the jury.
Okay.
Yeah, they stay.
But then they're still at sidebar. Okay. Oh, this is like the starting like that. So Bev says, hold on, we're back on the record. That's like when cops like point out that their body camera is recording. It's like, wait, don't keep saying what you were just gonna say. Hold on, we're back on the record.
Okay. Oh, this is all Yannetti. All right. Oh, I brought a backup tie. I just mentioned to Mr. Lally, he's been kind enough to give us advance notice of the witnesses he has lined up for the next day. And tomorrow, after Matt McCabe, we've got Jen McCabe, Carrie Roberts, and then 2 witnesses that I think are going to be fairly brief. So I just wanted to make sure there is nobody else after that. So we have binders and binders and binders of information.
I understand. This is how I always tried cases, and this is how the Norfolk County DA's office. Who do you expect to have tomorrow, Mr. Lally? Why she answers this, or should that be Lally?
That should be Lally.
I anticipate we can finish up with Mr. McCabe. Then Jennifer McCabe will be after that. Carrie Roberts will be after that, and then Laura Sullivan and Marietta Sullivan. Okay, but my expectation just on sort of how cross-examination lengthwise has gone. And direct, but I imagine I'd be surprised if we get to or even get through Miss Roberts. I hope we do. The repetitive nature of the setup and where people were sitting is just stop that. Hell yeah, Bev. I was only doing it with reference to this witness, Your Honor, because I think it's germane as to when he's looking out and where he's going and looking out, which is fine. But that was toward the end of your direct. The beginning of the direct, I think if you asked a question on who was there for the night, I think the jury has an answer at this point. So just try and cut it down now. Absolutely. Okay. So are we all set for tomorrow?
Jackson, just for prep purposes, do you have any idea?
You need to come closer.
Just for prep purposes, because I'd like to use the afternoon wisely. Do you have any idea who you might have on Tuesday?
I would love to know too, but I'm not asking Mr. Lally that. If he wants to tell you that, that's fine.
Okay, we can talk about it offline.
That's fine. Thank you. All right. We'll see you tomorrow. Whereupon the court adjourned at 12:55 p.m.
There we have it. I think that's the end for this day, or this transcript.
We did it. Should
we do another one?
Yes, of course. I feel like we need like a debrief.
Okay, yes. Let's debrief.
Yes. What are your thoughts so far? Okay, I guess my question is, like, you've read other sidebar transcripts, you've like participated in other like conversations with judges and lawyers. Is this typical?
I mean, the sort of the working together at the end of the day is typical. The fact that you have to have an objection on relevance grounds and go up to sidebar is not typical, especially because there are several times in this transcript and others where they walk up and say, okay, what's the objection? Like they go up to sidebar, they don't even know what they're really talking about because no one knows what the objection is. So that's obviously not normal. I think it's clear from the record that come hell or high water, evidence of harassment was going to come in, even if Lally did not actually, even if Jackson didn't elicit it and open the door, like they were going to find a way to get in harassment evidence. I do not think that the questions asked warranted opening the door for Colin Albert.
How long have you been thinking about this? Oh, it's harassment.
Yes.
Well, also, I just checked. So you know how in that last one, Lally was being like so sketchy about who was coming after the Sullivan sisters.
Mm-hmm.
It was Brian Higgins. So I think that is a pretty good indicator of why he was being so sketchy.
That is interesting. I mean,
it's like when you have a murderer on your side as a witness, you might not want the other side to have enough what's the word, like a head start on prepping for him.
Definitely, absolutely. You prep witnesses, even have them sit in the courtroom or hang out outside the courtroom. Maybe if the chance of them being called is very slim because the other side is going to be working to defend against it. Anyways, this is just, it seemed like Jackson was realizing during this transcript, he was sort of realizing how this case is going to go for the whole time. It was like, Your Honor, we're getting to the point that we cannot say or do anything. It's like he's realizing that for the first time, and I imagine that he got used to it. And by the end of trial, and obviously by the second trial, he's like, yeah, we're not. I'll fight, but we're gonna get little to nothing.
It must have been so interesting to be in his head, like the first moment where he's like, wait, like what? Why are you? Oh, this is just like how it is. Oh, okay, great. Where are we going next on this journey?
So I don't have one with like numbers written down or anything. I think we started to do some from 12 yesterday that were fairly lengthy, but you might have to do like a control F situation
that's
to find them. Okay.
I got that.
And I can't remember what that day was, but I think it was, well, we'll see.
May. Yes, hold on. May.
It's interesting because Jackson is clearly doing some investigation of the parties on the stand, which is just painful. I mean, I do civil litigation, so we've taken depositions of the key witnesses before trial, but I understand that depositions aren't terribly common in criminal law, and so he's getting up there and he's sort of exploring information that he didn't get from the Commonwealth that he should have gotten in discovery, and it's a very uncomfortable feeling for defense attorneys to have to learn new information on cross, which in theory, you've written out your questions, you've planned it to a T, exactly what you're going to say, but you also need information. Like, as we saw with Barros, the information was somewhat elicited, but he didn't want to go any further, or they didn't want to cross him because they didn't know what he was going to say.
Right. Yeah, totally. So May 7th is volume 12, and it has Goode, the Canton's newest finest, and Lank, who is Charles Ray? Is that an officer?
I don't remember that name, but I think he said Lally referenced a Lieutenant Ray earlier.
Sidebah. Also one thing I wanted to ask you, Bev talks a lot about like her job is to like basically kind of like task manage the trial, like keep them. Oh, okay. Trial Channel's the best. Charles Ray is the one who did the wellness check on the kids. So
Okay.
And the dash cam from them driving up that may or may not allegedly have been manipulated by Colin Crawford. How accurate is that like a major role of the judge is to make sure like the jurors are engaged and that the trial is like fast paced?
No, that's not a thing. The judge has discretion over its schedule and the docket. So if there are things like cumulative evidence coming in, and that's the court, can say, pick it up, Mr. Lally, like a couple of times when she said, okay, like enough about the seating. That somewhat makes sense. But in terms of like badgering Jackson about like wanting to play a 2-minute video twice, that's absurd.
Yeah, okay. That's what I thought, but I just wanted to make sure. Yeah, so Ray had the dash cam video that like Twitter friends love to say, well, what about in that picture? Look, it's cracked, and the police officer didn't have it yet.
I see. Yes, I recall now. There's so many witnesses from trial 1 that I completely forgot about.
I know. Okay. Whereupon there was a sidebar conference as follows. So, Your Honor, I'm a little confused. Could just end there. But Miss Little grabbed me right before. First, I apologize for my tardiness this morning. Miss Little had referenced to me just before the court came out that they had blacked out something to do with TUI materials, and I'm just a little confused on that. Okay,
So I'm not going to be showing these to the jury now. If there's an issue with redactions.
All right, they can come in later.
And I'm Yannetti now, by the way. This is my Yannetti tie. Well, I'd like them admitted now if I can, but subject to whatever redaction comes before the jury ever sees them.
They will remain here. I'm not admitting them. I have some leeway on admitting exhibits.
Of course, I know.
Especially on cross-examination.
I know.
Okay, so I'm not admitting them because We have to make sure all records are redacted. I have no doubt you'll be able to get them in, just not right now.
Okay.
So we will mark this for identification.
Court
Marked for
reporter.
identification, Your Honor.
There we go.
She's like, here you go, Your Honor. Your Honor, I'm sorry. Scene.
It's
Oh,
not.
no, that's not. No, that's not scene. Sorry. I thought that's where it ended. Your Honor, I'm sorry. All I wanted to say is I don't know where those came from because I don't recall that being in the material. Okay, so let's get in with the evidence. Let's get in with the evidence. We can discuss this. Well, I believe it's already in one of the exhibit books as far as the copies that I got from Canton PD and I provided to counsel, but I don't know where that came from. Okay, so it's not in evidence. It's marked for identification. Thank you.
It's so bizarre. Like, he knows what in evidence means, but he's like, well, it is because it's in like a notebook. And she's like, no, that's not, no.
So when it's marked for identification, that means like they have it kind of like cataloged, but the jury won't end up seeing it until it's like pushed through into evidence. Is that correct?
Yes, that's a good summary of it. I mean, there's always the possibility that the witness can't authenticate whatever it is, so they're marking it to have a record of we tried to get it in and couldn't or something like that. But yes, that's the process.
Okay, here's the next one. Yannetti.
Okay, sorry, my screen's freezing somewhat. Okay. All right, Yannetti. I guess I'll hear the objection first. See, this is another example of they go to sidebar and he's like, I don't even know what Lally's going to say is the problem is.
Go ahead with your objection. I don't see how any of this is relevant, number one. Number two, as far as it was already testified as to what it is, I don't understand why these need to be put in. Wait, can I scroll back and just see like what's happening?
Yeah.
Or I don't know if we're really going to be able to tell, but or like who's on the stand or anything.
Oh, these are the reports with, I assume, Goode? Yeah.
Okay. Oh, so this is the report where Goode filled out his report with a picture from the scene where there's no taillight because there was no taillight on the scene when he got there because it was the morning. And then they updated the report with a picture of taillight just like for funsies.
Yeah. For cinematic effect.
It's like a it hooks the reader better.
All right.
Okay, sorry, where were we?
So this is going to be helpful to the jury. What I'd like to do, and Your Honor, with regard to police reports, Your Honor is 100% correct. Typically, you don't admit somebody's police report with the narrative and all of the hearsay that it contains. That's not what I'm looking to do here. And in fact, if the court only wanted to admit the top half of both of these forms, that would also be fine.
Also, the no crime involved, there is a lot of hearsay. So what you want is the pictures, Mr. Yannetti, right? That they're separate pictures.
But I think it's far more powerful if the jury sees that the information is identical. And in fact, we can redact the, quote, no crime involved language. I don't need that. The other stuff is just, I'm not offering it for the truth of the matter asserted. I'm offering it to show that it matches and what I think it doesn't match. That's why it's relevant.
But he said he didn't know why this had 10.
No, he actually said he did. That's the print date.
Well, you said the print date, and he said, I guess. All right. Printed by whom? The police station or you guys?
No, not by us. This is a police document.
So you just want these photos in to show that they are different?
Yes, but I want to show that they are part of the police report. They are part of an identical police report. I mean, the fact that there's, the police logo and it looks all official.
All right, so I will let it in, but I'm not going to allow you to publish anything on the screen because if this is indecipherable,
Well, we have ways of magnifying it.
exactly.
You can see it.
But maybe that's for a later time. I will let you put in the top part after these are, but no crime involved, because that would be hearsay.
Right, yes.
So I'll let you put in the top third of each of these reports in, and later see if we can expand upon them.
Let me ask you this. Can we black out the no crime involved now with the magic marker? And can I just show that what the court has in your hand right there on a split screen?
No, because I haven't yet seen the altered version of this. And again, the jury gets the evidence right here. The jury doesn't get, I don't know, have you seen what this is? Yes.
I believe you may have it on your desk right now, but I gave the actual exhibit.
I don't know.
I thought I saw it.
Do you have the actual exhibit? Jurors, feel free to stand up and stretch. While Miss Little is getting that, we need to still talk about Sergeant Lank and what exactly you intend to put in so that I can rule on exactly what I think.
Of course.
What you would be allowed to put in? Sure. Thank you, Miss Little. Okay, is this in evidence? I hate to say this without any reference to it. Not that. Do you intend to put it into evidence? Yes. So with that, if you intend to put this still into evidence, Mr. Yannetti, if you could, and is this berm in evidence or it is this a different one? All right. If you put that in first and then put these in, then I'll let you put it on the screen.
Okay, thank you.
Is there an objection to that, Mr. Lally? I do have to black out the, as to the photographs, no objection to that. As far as the report or any part of the report, there is an objection to that. All right. So as to the top, what is your objection? Again, I think it comes into a bit of a dangerous territory in the sense that if counsel is going to try to suggest there is some sort of difference between the reports, then I think we almost enter into a realm of the entire report coming in.
I just gotta say that is like so infuriating. It took 45 minutes to get out that explanation, which, and I'm sure you were doing it at the normal speed that he was talking. That is not an objection. He's essentially asking for rule of completeness. We have to show the whole report or something like that. Otherwise, that's not an objection. It's just like a general complaint of this could be dangerous for the Commonwealth's case.
Yeah, well, also like that's the point. He's like they're trying to suggest there's some sort of difference between, like, yes, there is. There's one difference, and it's this picture that's supposed to make it look like Karen's taillight was at the scene when it wasn't.
Sorry.
I think he said he's going to suggest that the reports are identical. The only change is this.
Correct.
So let's make that clear, okay?
Okay.
All right. So the report is put on the screen. That has to be whited out, and only this part can be shown.
Thank you.
But you have to put that in first.
Okay.
Your objection is noted, Mr. Lally. Miss Little, Miss Little will give that to you.
Mr. Lally, I'm sorry, just to make sure there are no mistakes. It's been suggested to me, and I think it's probably a good idea to cut this exhibit.
Okay.
There's nothing else that's shown for sure when it's put on the screen.
Wait, How are you putting that on the screen? I thought we already had it.
I was going to suggest Mr. Bates has the entire report because it's electronic. I don't want to take any chance to it accidentally being put up. So if we just cut it, we can use it using the Elmo. We've got an Elmo.
Okay.
Is that okay?
Yes. So white it out and cut it.
And just for the record, the P and Q exhibit stickers are above the point where we would cut it anyway.
Keep them on it because that's when we will put the exhibit number.
Correct. Thank you.
All right. And scene. So basically like 6 pages later, they did exactly what Yannetti was asking for originally.
I think so. And I really feel like the difference was whether we're going to black it out or white it out or cut it out, and nothing substantively at all, but whatever.
And I think they ended up putting it just on the screen like every other piece of evidence on. I like have a memory of it on that same screen. So I don't think they did any of those.
Yeah, this was kind of an absurd, like lengthy objection for no reason whatsoever.
Well, sounds about right.
That's just Bev calling out the attorneys in front of the jury for breaking some promise they made to the court, which is totally inappropriate, but not an actual.
Oh, wait. Oh, no, she kicks the jurors. Oh, wait. First she's rude, then she kicks the jurors out. And then she says,
oh,
do we have scissors, Mr. Clerk? She's doing like an entire craft project. She's like scrapbooking. Run it through the copy machine. Okay. Okay, so now the Commonwealth calls Michael Lank and immediately sidebar. So we still need to deal with this. I assumed you'd want to know before you did your direct. Yes. You were saying before you had the other officer available yesterday to go. Can you call him, or do I have to give this jury another break? And Mr. Yannetti?
Yes, Your Honor?
I expect better from you than that.
I think that is admissible, Your Honor.
I know you might, but it's not.
Okay.
Especially, we haven't had this conversation yet today about what I was admitting regarding that incident. So I'm just telling you that. Do you want to call the other witness, or do you want me to give the jury another break? Yes, I'm sorry. Miss McLaughlin. You want to be La McGlaw?
Well, McGlaw, Your Honor, I'd just ask if I could step out to see if he's here.
Okay.
I could step out of the courtroom.
Sure.
Okay.
Mr. Jackson, do you want to tell me exactly, do you want to do this now, here, while the jury is waiting?
Sure.
Let me just grab I'm going to send the jurors out for 5 minutes.
All right.
Jurors, I'm so sorry to do this. Didn't they just decide they didn't need to send the jurors out? And then she's like they were all like, no, the jury can stay. It's fine. It's no big deal. And she's like, I'm going to send them out.
Bizarre.
Yay. You win. Okay, wait. So that was page 37. And is Lank just sitting there? I don't remember this. So they called Lank, he sat down, and then they just did all this.
That may have been when La McGlaw went to go find him. I'm not sure, or if she was, I don't know if she was looking for somebody else.
It sounds like they were looking for whoever was, maybe it's this Charles Ray. He's very elusive.
He is.
Okay. Oh, then they go for a little while.
Okay.
Maybe she got relaxed doing her scrapbooking project. Oh, the clerk starts this one. I just want to let the court know that we anticipate going. Wait, why would that be the clerk?
I feel like that's Jackson.
Yeah.
I just wanted to let the court know that we anticipate going into the relationship right off the bat. So if there's an instruction that the court.
With the whole incident right off the bat?
Correct, and get that out of the way.
All right, thank you. What incident are they talking about? I wonder.
I think that's the Lank.
Oh, the Lapalito brothers?
Yeah.
Okay. Whoops.
Okay. I just wanted to briefly let you know so you don't become impatient. I'm going to play about 5 minutes of this and stop it at certain points, about 4 different points in the 5.5 minutes in total.
Okay, just don't narrate it.
I won't.
Okay.
Okay. You do a really good job of like placing Bev's size. I feel like you kind of nail it.
Like, that is so wild. Like, okay, judge, like, please don't get mad. We're gonna play evidence. But please don't be mad. And she's like, oh, fine, I won't be mad if you don't talk during it. She's like, don't ruin the movie.
That's a great summary. That is literally what is happening.
Okay. So now what's happening? Do you believe in your mind? I have no idea who this is. Okay, we'll find out. What is the objection, Mr. Lally? It calls for speculation.
This goes directly to something. I'm not asking him to speculate. I'm asking him what his state of mind at the time was.
You have to ask it differently. You were asking him to speculate. Ask it differently.
Okay, yeah.
Okay, wait, I want to know who that was.
It was a very compound question. I don't remember who the witness was.
You thought it was maybe, is this good? They're on the scene. Like, why did they label the sidebars so thoroughly, but then everything else is just QA? Like, can you tell me who's talking?
Sergeant Lank. There, it
Okay.
said it. Yeah.
Okay. Oh, I love this one. Wait, I have to get like really annoyed right now. Like, Bev is like huffing and puffing and furious. Okay. So I didn't want to interrupt you and embarrass you. You don't put anything up on that screen without my permission. You did it 5 times. Let's go to tab 1. Let's go to tab 2.
I thought if it was in evidence that we were free to.
You don't just freely walk about the courtroom and put up displays.
Where would you like me?
Mr. Yannetti should have told you that.
How would you like me to? What is the proper protocol to ask? I'm so uncomfortable.
You ask me for permission to put something on the screen.
Okay.
Mr. Yannetti, you have a role with the Pro Hoc Vice to let them know.
I understand.
All right, the jury needs a break.
I've got about, just so the court knows.
Jurors, go ahead and take a 10-minute break, okay? Wild.
Just can't let him finish the sentence.
Like, he's like, I just have one more question. She's like, jurors, get out of here. Oh my God.
Does it continue or is it?
Yes.
Okay, Ms. Little, the same question by a different witness in the same position yesterday. Jackson, just so the court knows, I've maybe 10 minutes left, no longer.
And yours will be very short? Yes. All right. I'd really like to not bring him back again tomorrow. No. Will we start with another witness? I think we can probably get through with Lieutenant Ray.
Yannetti, I was going to suggest, Your Honor, I would really like the court to rule on the photos I brought up at the start of the day yesterday, because I think there is a chance Caitlin Albert could be called tomorrow.
I doubt it.
You doubt it?
The court reporter, I can't hear.
I had just said that I was hoping for a ruling on the photos I had brought up at the start of the day yesterday. I do have further oral argument to make outside the presence of the jury.
Why don't you make that right now?
Can I get my notes?
Are there pages and pages, or is this?
There's 3 pages, Judge.
Mr. Yannetti, I don't need to hear 3 pages of argument.
Here's the thing, all right? Let me just try to encapsulate it. I thought it would be appropriate to discuss what orders have been in place regarding reciprocal discovery. This court is free to make any orders it wants at any time. I recognize that. But I wanted to explain the reason why we didn't reveal the photos that were previously marked HIJK previously. And, it was our view that there was no specific reciprocal discovery orders that required the provision to the Commonwealth of material that we deemed to be impeachment evidence. It would have been within the court's purview to order it. And as I said, the court can order it now if it has not been ordered to date. And I recognize that. But that was the reason for that. So with regard to those 4 photos, I understand the court's ruling that they were inadmissible to use against Miss McLaughlin. My position, our position, is that we are in a much different position with regard to Caitlin Albert. Not only with regard to those 4 photos, but because now the Commonwealth is not surprised and they've had time to prepare here, and that topic of conversation would be part of our examination anyway. But with regard to particularly to these new photographs that we just received over the weekend, there's been no discovery violation with regard to that. I have a list on my desk of all the discovery that the Commonwealth has provided to us that continues to come in on a daily basis since this trial started. So, clearly this is not something that we held back. It's new, it's relevant. And the court indicated yesterday that, it may be cumulative. I would take issue with that because there's been no photo introduced of their relationship, and there's been an attempt by Miss McLaughlin to minimize that relationship. Now, these phones not only prove that she was minimizing it, but in my view at least, proof that she was lying on the stand about the nature of the relationship. She had said specifically 2 things. Number 1, that she hadn't had any contact with Caitlin Albert in the last 2 to 3 years. Come to find out, we have a photo from 8 months ago. 8 months prior to January of 2022, where there's a limited number of people in a photograph, and Caitlin Albert and Katie McLaughlin had their arms around each other at a baby shower. In addition, Liza, what was the statement?
The statement.
Oh, yeah. She had also said that they had only take day trips together to the beach. Well, we have a photo of them in Maine, 4 hours away, drinking in a hot tub, which is clearly not just a one-day trip. Then we have photos with just the 4 of them together where she's with Caitlin Albert's 2 college roommates. So there's Caitlin Albert and her 2 roommates and Katie McLaughlin. She started off her testimony by saying, I went to school with somebody by that name. That's like saying, I know somebody who raised me who happens to be a woman and is married to my father. I mean,
That's like quote of the year.
It's so good. I mean, she misrepresented the relationship. That is central cross-examination material, and these exhibits are relevant. So there's been no discovery violation, and I seek to use them during their cross of Caitlin Albert.
What do you say? Your Honor, what I would say is there absolutely has been a discovery violation. The Commonwealth filed a motion for reciprocal discovery, which the court, I don't know if it was acted on as far as writing on the order, but it is specifically stated to counsel to provide those. The subsequent do absolutely nothing to further any point as far as firefighter McLaughlin. And I remind counsel that it is a firefighter And that is how she is involved in this case and comes to the scene in the first place. Frankly, the cross-examination, I'm going to leave it at that because I don't want to say something I may regret. But with regard to most of this is cumulative, and the other sort of photographs that are, they went to high school at the same time, which firefighter McLaughlin acknowledged. They were on the track team. So were about 40 other people. Every other photograph that's contained in here is in a group setting, which is what firefighter McLaughlin acknowledged. There is absolutely no evidence whatsoever of any prevarication, any lying, anything mentioned in front of this court and flat out accused firefighter McLaughlin of doing. There is no evidence of that in those photographs, the other photographs, or anything about her testimony. And frankly, it's repulsive. All right, so I'm going to strike the repulsive part. All right, so I did find that there was a violation of Rule 14. I know that counsel said that you didn't intend to use it, but I disagree, and I find you did. So I will mark all of these for identification. There are 7 of them, and I made an independent finding that they are cumulative, that Mr. Jackson got the answers he was looking for, and that the photos are not inconsistent. So for all of those reasons, the photos from the other day are out, and these are out.
Specifically with regard to these.
Hold on.
I'm sorry.
Do you want them as one, or I think one is easier?
With regard to the.
Hold on.
I'm sorry.
All right. What's your question, Mr. Yannetti?
Just so I understand the court's ruling, with regard to those additional photos that we received over the weekend, is the court ruling that they're excluded in part because they too are a discovery violation?
I don't know where they came from or who authenticates them. Did you get these, Commonwealth?
I gotta say, as a side note, he is like, hey, it couldn't possibly have been a discovery violation. We just got them yesterday, essentially, or 2 days ago. And we turned them over right away. And she realizes that when he asks the question, she's like, what else have we got? Oh, authentication. Well, there's no one to authenticate them. Therefore, another reason, it's wild.
Like, she needs to authenticate these pictures of Katie McLaughlin, like, drinking in a hot tub, but doesn't need to authenticate the screenshot of Colin Albert's phone. Okay, cool. When the court did.
I had represented, we received these over the weekend, and in fact, we got.
Unknown sources.
Right.
And some are marked. Tori, can I have that, please? Thank you. So I don't hear anything right now that would make these admissible. You need to question the witness first. I don't have your discovery motion in front of me, Mr. Lally. Did it include impeachment material?
I can speak to that because I reviewed it. It did. If that motion was allowed, then my reading of the motion is that these, not these, but the previous 4 photographs should have been turned over. But I also.
Okay, the motion was allowed because I remember saying I knew you had to wait until a certificate of compliance.
Right.
And I said that the Commonwealth's motion is allowed, is my understanding, and you had to get it immediately. I think I said 2 days. I didn't know that even Miss Little complied much sooner than that.
Right.
What does that mean? Even Miss Little complied much sooner than okay. And I really would rather handle it in his testimony. Do you need much more time on this, hearing from all 3? Actually, just the 2 of you.
Well, I was just going to explain, Your Honor, that I checked the docket. The motion was not endorsed, but I don't question what the court just said.
Okay, I remember it specifically.
Okay.
The 2-day part.
That's fine.
Why don't we just continue? If you come up with another argument before the witness testifies, you can tell me about it.
Okay, thank you.
I really don't want to waste any more time.
I understand.
So we won't get a break. We'll just bring the jury in. Okay?
Fine.
Okay. I like how she always threatens we're not going to get a break, and they're like, okay, that's fine. That's cool.
I mean, she doesn't want to waste any more time. No one does. No one wants to drag this out for 1 second more than they have to.
At what point during Yanetti's argument of that do you think she wished she just let him get his 3 pages because it would have been shorter?
I could not agree more. I think the minute that she realized that there was no discovery violation on the new stuff, she was like, oh, God.
Okay, wait, well, that was one. Okay.
Jackson's back.
And who's up? I don't recall. Oh, so we're at Jen McCabe, right? Went back and oh no, wait, you went back and you.
I think this is Lank.
Okay, yeah.
Okay.
We're still. Lank testified for longer than I think I remember. Hold on.
Because he had a whole voir dire situation.
I need to rewatch. I haven't rewatched that one in a while.
All right. Your Honor, the court's order to me, to the defense, was that we were not to get into the specifics of the actual fight, which I closely guarded against. And I did not. Mr. Lally just did exactly what the court ordered me not to do. He said, tell us what happened involving this fight, giving him the detail of how he was punched first. He was attacked first. There was foul language used. There were threats used. And all he did was defend himself. With the court's permission, I intend to ask 3 questions. Number 1, you just described a situation in which 2 men assaulted a police officer, basically in front of other police officers. They were never convicted of anything. I won't go into it any further, but I'd like to say they were not convicted. Mr. Lally has indicated that they were charged, but I think the other side of the coin but they weren't convicted. The second thing I'd like to ask is, he made a statement saying, whoever you are, I'm going to make your life miserable. And that's on the record. He didn't admit it or deny it. And then the third thing is simply wrapping it up with, this was in furtherance of you coming to Chris Albert's aid.
All right. How do you respond, Mr. Lally? So, Your Honor, as it pertains to, I didn't have any indication. There was no indication that anybody was arrested, charged, or anything as it pertains to Lopolatos. So whatever happened with the case is not relevant and germane. As far as what I did with the witness was in response to Mr. Jackson's questions, which understandably on cross-examination, they can be leading, but essentially he led him through a certain narrative that I did not believe to be accurate. And so I asked the witness what his recollection of that narrative is. That has nothing to do with any of the subsequent trial intimidation charges or anything of that like, as far as his, and I'm sorry, I can't recall exactly what your questions were again.
Nobody can, Lally. It took 45 minutes, again, for you to get out nothing. And it's not accurate. I mean, he did exactly what the court said that Jackson couldn't do. Jackson is completely right there. But anyways. Okay. The main thing that I would need the court's guidance on or to alert the court to is I want to be able to ask him, given the narrative that he just described for Mr. Lally, anybody would expect that he would have been charged and convicted. I simply want to be clear that they were not convicted of anything, which suggests that his narrative is spinning the facts in his favor.
I also like that Jackson just completely ignored everything Lally just mumbled.
Every word.
So tell me the question again. I don't want 5 questions. You said there were 3 questions. I don't want 5 on the same topic.
Right.
What is the first question?
You claimed in Mr. Lally's questions, you claimed that you were specifically physically assaulted by, the fact of the matter is they were never convicted of anything having to do with the assault on a police officer.
What was the second question?
You
Even though you didn't tell me
indicated
the first.
you indicated that they said to you, and I will adopt my language accordingly, I don't give an F what we do. You know, I'm not going to continue to fight you anyway. On record, what was said was, he said to them, I don't know who you are, but I'm going to make your life miserable.
All right. Let me hear the first question again. I thought the first time he said something like, this happened in front of several police officers.
Right. Your claim is that you were assaulted in front of other police officers. They were never convicted of anything having to do with the assault on a police officer or anything else.
Regarding this incident.
Regarding this incident, yes.
I'm going to allow it, Mr. Lally, and I feel bad. It's the one time he did not really ask any leading questions, and all of this came in. So I'll allow the in front of police, you know. The first time you worded it was the best.
Okay.
I don't want you to get into all the details that Mr. Lally, just in response to Mr. Lally's question.
Right.
And the second one was?
You actually said to them, I'm going to make your life miserable.
Okay, all right. I'm going to allow it.
This one is absurd because I don't want you to get into the details of Mr. Lally. I mean, what she's about to say and caught herself was that Mr. Lally elicited from the witness against the court order because she doesn't want him to refute whatever Lally just elicited about who started the fight and who got hit first, whatever. It's stupid. It's a stupid thing.
And can we talk about this? And I feel bad.
I can't wrap my head around why she said that.
I'm going to allow it, Mr. So she's saying, I'm going to allow it, Mr. Lally. So she's saying, like, you're overruled your objection. And I feel bad. Do you feel bad because you let Mr. Lally say everything that he did? Or do you feel bad that you're letting Alan win one? I'm not that deep in her brain. I don't know. Maybe I will be someday. Okay. That one is one line.
And that's the end.
We're at the end of that. That's the end of that one.
Yes. I'm probably going to have to bounce shortly.
I know. I was just looking at the time. Oh.
I know, but this is fun. I love going through it, and it's so crazy, and it's much better to do it out loud.
I think that it really brings it to life. Here, just reading it, I think Bev seems frustrating, but when you actually think about how much she's interrupting them and berating them, you didn't ask my permission.
It's bizarre. I find that very obviously searching for bases for excluding things because when there isn't one is wild to me. And it's not a gatekeeper role that goes far beyond the gatekeeper. Like asking Mr. Lally, oh, but what about this or whatever? That's not normal. Just because she's doing it so routinely. If there was one issue where that needed to happen, fine, here and there. But it's every third sidebar, she's thinking of some objection that Lally didn't say in his ramblings.
I mean, it also kind of feels the same way that Lally objects to things. He's just throwing out the word objection, hoping that it sticks. And when it doesn't, and she's like, what's your objection? He's like, it's not germane to the case. Relevance.
He always starts with relevance. It's just, it's like a catch-all because he can't think of, the specific problem.
This is wild. Thank you so much for getting us these. It really is a whole other angle of the case that I think we all felt it, but couldn't didn't know for sure. And it's almost reassuring that we weren't all crazy. We weren't all completely losing it when we were wait, what is going on? Why are they all tiptoeing around Bev and this and that? It's now I get it.
Yes, that's a great point. Because it's not, yes, like you said, it's not Karen's defense team being all crazy. They're like providing valid solutions. And the fact that Jackson is able to articulate his specific questions, complex questions, and across the next three off the top of his head and restate them multiple times and revise them, that is not easy to do. Obviously, Lally cannot do it ever. He can't even do it when he's asking the witness the questions, much less forecasting what he's going to ask at sidebar. And Jackson is just ripping off like really good questions off the top of his head. It just he's just such a brilliant trial lawyer. I know everybody knows that, but it is consistently evident, especially at these sidebars.
And he's having to defend himself. He's like in a roast half the time. She's like, I thought you were good at your job. And he's like, I am good at my job anyways.
That's exactly what's happening. And this is only 2 days of the sidebars.
Also, people are loving your outfit. This is really cracking me up. Somebody asked when you're going to do a blues number.
Dan Aykroyd. I was afraid I was getting into Karl Lagerfeld territory, but not like the good way, like in the old sort of too much way. But Dan Aykroyd that works.
No, you crushed the outfit. You crushed the acting. You are, I mean, is there anything that this woman can't do? Oh,
definitely.
I love that. Actually, that's even better that you have like a thing that you're not good at. I bet you're also like, no, I wasn't good at like advanced calculus, trigonometry, something I didn't take.
Stop.
I don't want to keep you from your family. I know that you have a fun night planned and then you have a busy week ahead of you with the holidays and stuff. But I do think that there needs to be a follow-up part 2 of this because the sidebars demand it.
I would be honored to participate. Thank you so much for having me. It's always a blast. I love your show. I love being on it. I love watching it.
No, I mean, literally the pleasure is all mine to a degree that I don't even think I can articulate. You are
No, I can't.
Like
no, I can't.
Okay, I'm all done.
I can't.
Okay.
Thank you so much. Happy holidays to all the sea creatures, and I will hopefully see you soon.
Thank you so much. You're literally the best.
Bye.
Obsessed with you. Bye. You guys, how fun was that? I didn't get to look at the chat at all. Well, I looked like I was just being Bev. Which reminds me, before we wrap this up, there is a life lesson in this bad attitude Bev, because the top picture of Beverly Cannoni was her pre-trial before trial 1. And the second picture is towards the end of the retrial. And when you are all stressed out all the time, when you're on the wrong side of justice, when you're on the wrong side of what's right and wrong, it takes a toll on you. Like, we just need to take a minute and like look at her skin in the first one, look at her hair in the first one. Like, that is a woman that is like happy with herself. And in the second picture, that is a woman who is not proud of herself. And when she's not proud of herself, she's not taking care of herself, and it shows. And I think that should just be a lesson for all of us, that if you live a life that is moral, that you can be proud of, it will show. And you don't need all these like skincare routines and hair care routines and fancy products. All you need to do is not act like Beverly Cannoni ever. That's my beauty advice for the day. I want to make sure I check in with you guys. Okay. Yellow Ledbettero, my court buddy Kim, said, hiya. Sorry, I didn't ask this when she was here. Has Queen Corri ever seen a judge that has scrutinized the defense motion / asks more or equal to how Bev did in this case? It sounds like no, this is not normal. That's I'm going to answer for her, but I'll ask next time. MLC became a YouTube member, and like we basically have the same name. So like, thank you we're like family. South Boston Kev said, objection, the sidebahs are classified, hashtag top secret. I guess not anymore. Cat Savage Art sent $10 and said, Merry Christmas and thank you for all you do. That's so kind. Also, I like your logo, and now I want to look at your art. Chrisman 8231 became a YouTube member. Welcome. The lawyer you don't know. Huh. I like that name. I'd like to know you. Became a YouTube member. Kat Randall said, Corri, thank you. On a mission from God, everyone has a role. AKA Blues Brothers. She's so good. Like, also, I love how well we know the lawyers, because her shift from Jackson to Yannetti was so good. Like, you can like feel Yannetti's like warmth, and then you can feel Jackson's like determination. That was so fun. I wish she didn't have to like have a real life too, and we could just keep doing this all day and all night. Kat Randall became a YouTube member. Thank you. And B Crumbs 937 gifted 10 memberships. That's so kind. Welcome to everybody who got those. I've never gotten one of a gifted membership, and I, like, every time I'm like, is my thing turned on? And I'm jealous every time people do. Kelly V became a member. The Goodmans said, we love you, Emily and Corri. Thank you so much. We love you too. Merry Christmas to you guys too. That was seriously so fun. I like really don't want it to end. But I also did want to end at 6 because Nurse Kim was so considerate and saw that we were doing this at 4 and moved her show around to accommodate for this. So I have it set up. We still have 5 minutes, but I could just babble to you for 5 minutes. But I have it set up so that it sends you to Nurse Kim right after this, because she's the best, and I'm going to be there in a minute. Karen Goldberg said, you are probably one of the only light on Twit. That's so nice. But also, like, I feel like we can all like be the light. Like, actually, we're going to do a little like sermon right now, because keeping Bev in mind, when you go on social media, people, and you think about not just the way that you're responding to content or the content that you're putting out or the message that you're putting out, but starting with the content that you're seeking out. Like, you can curate your Twitter feed, you can curate your Instagram, you can curate your TikTok, whatever it is, to make the content that you're being fed content that will like pour into you, aka Bev in the first trial. You can find the content that you won't get sucked into, that won't feel negative, that won't bring you down. That's step 1. Step 2 is, when you do see something that you feel yourself like negatively reacting to, here are a few tips. Number 1, you can keep scrolling. You can say, oop, I didn't like that feeling very much. I don't want to feel like that. I'm going to keep scrolling. That's number 1. Number 2, you can type out what you wanted to say that would like put negativity into the world, and then you can delete it, and you can like get it out and then delete it. If you're not sure if it is something that is going to put negativity into the world or not, you can type it out, then read it out loud to yourself and imagine that somebody was saying it to you. And when you hear it out loud, think about if you would like, oh, there's scheduled for 6:30. Well, then I'm just going to babble to you till 6. But you can think about, is that something that you would want to hear somebody say to you? And if it's not, delete it. Another tip. The battle, let's learn from Corri. the battles that Corri has been fighting are the battles that are worth fighting. Like I know a lot of us can't like sue the Commonwealth because I don't know how to do that. But there are real fights that are worth getting into, and that are worth pursuing. And not everybody needs to be in the fight with you. So I don't feel compelled to like go around the internet and make everybody agree with me. Like, I actually don't care if I encounter somebody who like thinks Karen's guilty or doesn't like Aiden or this or that. Like, it's not important to me that everybody is aligned with me, because like sometimes I'm not aligned with sometimes I change my mind. Like, I think we can seek out the people that we connect with genuinely. And then when you find somebody that you don't connect with and you don't align with, like, great, they'll have different friends that are not me. And that's fine. That's allowed. Yeah, I like this mindset too. Jenny Lulu said, I'm always looking to hear other perspectives. Like, hearing other perspectives doesn't need to be an argument. Like, it doesn't need to be a fight. You can be like, oh, wow, like, okay, I hear you. I don't agree with you at all. Interesting. Thank you for sharing. I think a lot about like people in sports bars who are rooting for two different teams and are like have an argument about like my quarterback's the best, your quarterback's the worst, like whatever. In those disagreements, they're not trying to be like, and now be a Red Sox fan, now be a Patriots fan. Like, you're not trying to change the other person and get them onto your team. And I think that's a good way to kind of like have these conversations in general. I'm literally the worst babbler. Welcome to my brain. This is everything that happens inside of my brain all day. I really actually just cannot say enough about how appreciative I am the way that you have all made me like feel comfortable being on here. Like, I think back to my first stream a little while ago when I just panicked the entire time. And now I feel like I'm just sitting here rambling to you guys. And I will probably just panic afterwards when I rewatch it, but I'm at least not right now. Big Ed 420 said, please don't let up until the feds are on the job. Yes, this is the correct yes. Where are they? And like, how can I, like, if they don't have enough resources or something, like, it deputize me for 1 week. I'll do it for free. I'll go through all the paperwork. I'll like highlight, I'll file, I'll color code. I'll make you like timelines and charts, whatever they need. Like, consider this my job application, and I will happily investigate anybody that they want me to. I'll start with Higgins, allegedly, but really anywhere that you want me to start is fine with me. Please. Thank you. Yeah, but where are they? Like, come on. This was fun, you guys. I really, truly, also, can we just thank the Trial Channel over and over and over again? Number one, for just being one of the best people on the internet and just one of the best people in this world. And number two, for always being here and being the best mod. Thank you. And also just having the best content on YouTube, where this is all so much easier to digest because of Trial Channel. Or as Justice Served TV calls it, Trial Network. Very catchy name. Yeah, there could have been some drinking involved. Ginny said, Bev looks like that because I truly believe she's an alcoholic. Allegedly, I'm going to start saying allegedly all the time so that I don't get in trouble on this platform. But some of those desperate attempts to get to a break in the sidebars seem like Bev was desperate, or maybe she needed to poop. That's the only other reason why you would be like that desperate to like get out of there that quickly. So, you guys, really welcome to my brain. I don't get road rage like ever. Like I don't get frustrated with annoying drivers, because anytime that somebody's being really annoying, I just tell myself that they're probably sitting in their car needing to poop really badly, and that's why they're driving so aggressively. And then I'm like, oh, that sucks to be you. So another life lesson. Okay. Natalie said, I've said it before, but Emily would be 100 times better than any law enforcement investigator we've got, but the culture is too awful to interest someone like her in applying. That is true, not for the culture, but because I'd be like, oh no, it's fine. Like I'm the most gullible person on earth. I could not investigate anything, because no matter what somebody said, I'd be like, oh, okay. Well, that's what they said. Maybe not with investigations though. But it does seem like, I don't know this for sure, but my read on the situation is that is kind of what happened with the interim chief of the Canton Police Department. What is his name? Maybe Perkins. I might have just made that up. But it sounds like he is like just a very good guy and really knows what he's doing and has his priorities straight. Every time that Corri corresponded with him, she was so like appreciative of how responsive he was and how open he was, and completely different than anybody that she had interacted with. And he's not staying on. He was the interim and really like got out of there as fast as he could, because it's hard, I think, for a good person with good values and good morals to come into somewhere that's used to being negative for so long and really making change. Like change is hard. And I think change takes like this sunlight that we're so grateful to Corri for. Okay. This was really fun, you guys. I would like, if Corri can't come back for a little while, because like she has like a real life and like a family and like a real job and all of this, I wanted to at some point go through some of the other transcripts with video from the trial channel and kind of play get the lay of the land of what was happening during the testimony that day, and then get into the transcripts. So look forward to that at some point. And thank you all so much for being here. And I hope you have a wonderful rest of your day. And I'm trying to think if I'll see you guys before the holidays. But if I don't, it's like in the Truman Show, like good afternoon, good evening, and good night. If I don't, have a wonderful holiday season. I'll probably be here before then. You guys are the best. Thank you so much. Good night.
John Keefe was 46 years old. Psst, Peg, time to cry, because remember, oopsies, you thought he was 45. John Keefe was not a buffalo on the prairie. When I was a kid, I used to throw boulders off of bridges. Ah, what a thrill. The dater is the dater. And tonight, I'm going on a dater with Shannon Welcher. We have no idea how the collision happened, but if you have any doubts left, remember this. My best friend, Jen McCabe, said Bella's mom. Of course Karen hit him. Speaking of Jen McCabe, she's a soccer mom. She doesn't use Signal like Arca? She keeps everything right out in the open, like how long until John dies in the cold? Didn't need Michael Proctor. Tully is our Uber driver now. As the trial ends, we remember Barrows lied not, Kelly Dever. I know our times changed to whatever, but cops can't solve crime in bad weather.